SJC-11873, Regency Transportation, Inc., v. Commissioner of Revenue.
Mr. Morris, good morning.
Good morning. Good morning, Chief Justice, Associate Justices. My name is Matthew Morris, and I, along with my co-counsel Richard Jones, are here on behalf of the appellant, Regency Transportation. This is a direct appellate review of an appellate tax board decision that found in favor of the appellee Commissioner of Revenue. Your Honors, this case is about the unconstitutional imposition of the Massachusetts use tax on Regency's entire interstate fleet of interstate tractors and trailers, which traveled only 35% of their mileage within Massachusetts during
But
the
I take it. Go ahead.
No.
No, go.
They are actually, this is the place of business of Regency, correct?
Regency is incorporated.
Home of the tractor trailers? I mean, I understand they drive all over the place, but this is where they reside.
Well, I'm not sure we can say that this is where they reside, or this is where Regency has its corporate headquarters here in Massachusetts. Regency has a terminal location here in Massachusetts, but they also have a terminal location in New Jersey. And as you mentioned, the vehicles are constantly moving throughout interstate commerce.
So it's a tax on storage and use, right?
It's a tax on storage, use, or consumption in Massachusetts, correct?
But this tax is assessed once, right? It's not assessed on the truck every year.
That is correct. That is correct. It's a one-time tax, and that's how it was assessed in this case. Your Honor, the application of the tax in this case violates the U.S. Supreme Court's complete auto transit versus Brady test, which both the U.S. Supreme Court and this court have adopted in order to determine whether a particular state tax violates the Commerce Clause. The use tax here violates prongs 2, 3, and 4 of complete auto because the tax is not fairly apportioned, it discriminates against interstate commerce, and it's not fairly related to the services provided by the taxing
Could
authority.
we talk about the apportionment issue? I gather that you're basically saying that by virtue of a regulation, the credit mechanism, which the Commonwealth relies upon to establish that it meets that prong of the test, which otherwise it might not without a credit mechanism. You're saying that the regulation basically limits the amount of credit in a way that is problematic.
That's correct,
right?
Your Honor. There are two discrete sub-requirements of this first prong of complete auto, which is fair apportionment. One of the discrete sub-requirements is internal consistency. And as the U.S. Supreme Court recently decided in the Wynn decision, we apply internal consistency by replicating the tax at issue to determine whether interstate commerce is subject to a higher burden than intrastate commerce, or commerce solely within the state. And the internal consistency problem here in this case derives from the structure of the credit mechanism. You mentioned the regulation, and we believe that confirms the internal consistency problem here, but the internal consistency problem really starts with the statute and the statutory
Do you
credit.
disagree that the statute would apply to both sales and use tax?
Yes. Yes.
Even, has it ever been applied only to sales tax and not use tax? Put the regulation aside.
The issue here, Your Honor, is we find that the statute speaks for itself. The statute refers to sales upon
Sale
which a
means something that has been sold and is coming here for use. I mean, it's in the use tax statute.
Correct, Your Honor, but sales refers to a transfer of title or possession. So the entire credit in the statute stems from a transfer of title or possession. You're correct that it does mention sales or use taxes paid to another state, but that doesn't mean that the sales or use taxes couldn't derive from a sale transaction. And let me explain how that could take place. In a situation where a vehicle is...
The one in your brief? That example, or were you going to...
Well, that's the example we provided in the brief is that of a hypothetical trucking company which purchases a vehicle in New Hampshire and pays no sales tax. That vehicle is brought to Vermont in interstate commerce, is assessed, and pays a Vermont use tax. The vehicle is thereafter brought into Massachusetts interstate commerce, is assessed, and pays a Massachusetts use tax. That type of tax that's paid to Vermont is not creditable under the plain language of both the statute and the
Well,
and
but
the
the- but the
regulation.
What if we were to
commission-
say it was? I mean, the
Yeah.
department says it is.
Yeah, the department says it is, under
The
the statute.
department now says that it is. The department is currently disavowing his own regulation and
Well,
stating
put
that
the regulation aside, just the statute.
the statute refers to sales, Your Honor. If you look at each of the,
So you think the reg is right, in other words? You think the reg accurately reflects the statute?
that's exactly right. And we admit it's a strange position for a taxpayer to be in
Certainly
before
is.
this court to say that the
Well, let me
commissioner's own
ask you thi-
regulation is a reasonable interpretation of the statute, but that's we're in that
It's the- you're
position,
saying
Your
the
Honor, because the
statute's the
commissioner is
problem.
disavowing his own
Right.
regulation.
If we were to say that the statute means as the commissioner says it means, do you have a problem under the first prong?
Can you repeat the question, Your Honor? I'm sorry.
If we were to interpret the statute to mean what the commissioner says it means, would you have a problem would you have an internal consistency problem?
No, we would not, if the commissioner position, which he's now adopting for purposes of this litigation, is correct, and that the credit extends to all sales or use taxes paid to other jurisdictions, which we do not believe it does. But if it did apply in that manner, then we wouldn't have a problem under the internal consistency sub-requirement of fair apportionment. We would still have a problem under the external consistency sub-requirement. And external consistency, Your Honors, is an entirely different analysis. External consistency is focused on whether the state is limiting itself to its fair share of in-state activity. And in this case, we have a fleet of vehicles that has only used 35% of their time in Massachusetts, yet we have 100% unapportioned use tax. Both the board and the commissioner in
Have a
their
100% unapportioned use tax because it is not being taxed anyplace else.
that is correct, Your Honor.
I mean, if
That is
in fact there were other taxes and you were getting credit for them, then you wouldn't have that problem, would you?
the test under internal consistency, Your Honor, is not whether the
I thought you were talking about external consistency.
we are, Your Honor, but that's why external consistency is a discrete analysis. So instead of looking at the structure of the tax and replicating it in every state, with external consistency, what we're looking at is the state's fair share. Is the tax related to Massachusetts' fair share of activity
So you're
in
saying
state?
let's just get down to the bottom line here. You're basically saying that because it only uses it in Massachusetts in terms of mileage to an extent that is less than 100%, that has to be the maximum tax, notwithstanding the fact that credits are or are not given.
The maximum tax in this case, Your Honor, is zero. There really is no tax that can constitutionally be assessed
There's no tax that can be constitutionally
because there is no structure in the use tax statute or the use tax credit or the commissioner's own regulation to apportion tax based on
But
mileage.
you want to make it a tax on mileage. That's not what a use tax is. I mean, you would treat it as you do say this, it's sort of like a gross receipts task. And so, but why is it? It's about use or storage or consumption in the Commonwealth.
The reason why it's closer, Your Honor, to a gross receipts tax than a sales tax is because of the nature of a sales tax.
Well, I understand that point, but the fact is, it's not taxing, it's not in-state people who, if you were a Massachusetts company operating exactly as you do, with trucks going all over the place, they would pay the same use tax as you do, right?
If there was a Massachusetts company using the vehicle and
I mean, say you're an S corporation where? I know
a
you're.
Massachusetts S corporation.
Okay, but but an in-state, if it's consumption and storage and use, an in-state company doing this pays for those things, and so do you, right?
That's correct, Your Honor. But the difference here is the schism, the difference between sales and use taxes that is explicitly addressed in Jefferson Lines. So the Supreme Court in Jefferson Lines addressed the differences between a sales and a use tax. The court stated, however complementary the goals of sales and use taxes may be, the taxable event for one is the sale of the service, not the buyer's enjoyment or privilege of using Massachusetts roads.
But that's not what the use tax is either, though. It's not the privilege of using Massachusetts roads. That's what I'm trying to say.
Regardless of whether we're talking about the buyer's enjoyment or privilege of using the roads or use of storage, use, or consumption of property within Massachusetts, the external consistency analysis is exactly the same. In a situation like this where we're talking about use, which is not happening discretely within one state in which only one state can lay a claim on that activity, Regency travels in 20 states on the eastern seaboard. Any of the states in which it's traveling could assess a use tax for the same storage, use, or consumption in Massachusetts, not just violating the internal consistency requirement by imposing multiple taxes. The problem is that there's just a discrepancy between the amount of actual use and the tax itself. And the problem with that is that it violates the principle enunciated by the Supreme Court in Central Greyhound lines.
But Central Greyhound, I believe, is itself an internal consistency case, is it not?
No, I do not agree, Your Honor. I think that Central Greyhound lays the foundational principles for external consistency. And it may stand for other propositions, but the part of Central Greyhound that I'd like to focus on is the fact that in Central Greyhound you had a bus company that was traveling amongst various jurisdictions in interstate commerce. 58% of the mileage was traveled in New York, and 42% of the mileage was split between New Jersey and Pennsylvania.
But am I right that there was no opportunity for credit there?
Well, let me just address that. So the court first noted that there was a possibility of multiple taxation. They said that both New Jersey and Pennsylvania could have laid an apportioned claim on the proportionate share of the gross receipts. So they said that that was the first issue that they were concerned about. But the court went on. The court said that even if neither Pennsylvania nor New Jersey sought to tax their proportionate share of the revenue, such abstention would not justify the taxing of New York by the entire revenue. By its very nature, an unapportioned gross receipts tax makes interstate transportation bear more than a fair share of the cost of local government whose protection it enjoys. And that is the exact principle that we're asking this court to apply here, Your Honor, regardless of whether we're talking about a gross receipts tax or a use tax. The fact is that use is apportioned for Regency in multiple states, and it's not an isolated in-state transaction like in Jefferson Lines. And that is why we're asking this court to apply the same external consistency analysis of Central Greyhound. The court in Wynn stated that if there's a failure of internal consistency, that type of tax is going to fall into a category of taxes that inherently discriminate against interstate commerce. So we've already discussed our position regarding the structure of the credit, which, Your Honor, the Commissioner has enacted a regulation or has promulgated a regulation that we feel properly interprets the scope of that credit. But aside from the credit issue, there's another aspect of discrimination here that I'd like to address, and that this is what the U.S. Supreme Court has addressed in American Trucking Associations versus Shiner, and that this court has addressed in American Trucking Associations versus Secretary of Administration. And that is that the cost per mile in Massachusetts for an interstate carrier, like Regency, that travels only approximately 1/3 of its mileage in Massachusetts, is approximately 3 times greater than that of an intrastate carrier that travels all of its mileage in Massachusetts. This court, American Trucking Association, said it is intuitively obvious that local trucks derive a far greater economic benefit from the challenge fees than the interstate trucks. And this is the same reason why the Alabama Court of Appeals invalidated the use tax in the Boyd Brothers case.
But why do you only count Massachusetts miles in that? I mean, if your trucks go 100,000 miles nationwide, they're going to be paid the same 3%, and if all those miles occur in Massachusetts, they're going to still pay the same 3%. So why is the cost per mile different?
Because it's the cost per mile within Massachusetts.
Well, that's how you frame it, but why does that make sense? Why is that? Why does that change the burden interstate as long as there's a credit for anybody else who seeks to impose a tax on them?
The court in Boyd Brothers said that the injustice in that case, the discrimination problem is that in that case was that a carrier that's based in Pensacola, Florida, that just makes one delivery across the state line in Mobile, Alabama, is going to be subject to the same 2% tax, in that case it was a 2% use tax, on the entire value of his vehicle as the interstate carrier that is based within Alabama and travels thousands of miles within that state.
Now, Boyd Brothers is not a United States Supreme Court
No, it
case.
is not, but it is the
It's not even a
only
Supreme Court.
case on
It's
point.
just an Alabama case.
It's an Alabama Court of Appeals case, but it's
We're not in any way bound by that.
you are not in any way bound by it, but it is the only case on point that addresses the exact situation at issue here, which is the state's attempt to impose an unapportioned gross receipts tax on an entire fleet.
But
of
in,
interstate
in
vehicles.
I mean, I've not read the Alabama case, but I gather they were not headquartered in Alabama and did not have a storage facility in Alabama.
That's correct, Your Honor, but I think it's
Doesn't
important.
that, doesn't that matter?
We don't think it does matter, Your Honor, because we have to separate Regency as a corporate entity, a Massachusetts S corporation, from the property on which the use tax is imposed, which is individual tractors and trailers. We don't feel that this should become a corporate domicile issue or questioning where Regency is located as a corporate.
But if you're storing and maintaining your trucks, it's Massachusetts who is responsible for the police, which you're going to call the Massachusetts police if there's a theft or if there's a vandalism. Doesn't the fact that you're headquartered here and store and maintain your trucks here matter?
There's evidence in the record, Your Honor, to illustrate that Massachusetts is not the only jurisdiction in which these vehicles are stored and maintained. And in fact, the only objective metric that we have on the record to determine the use is regarding the actual mileage in Massachusetts. So there's really no evidence.
Don't you also know that 35% of the repairs and maintenance is done in this state? I thought I saw that somewhere.
There is some evidence to that effect, Your Honor. So we do have some evidence regarding that, but we feel like the only objective metric moving forward, if the legislature were to enact a system like Minnesota, which apportions use taxes for purchases of interstate commercial vehicles, is to look at the mileage that's reported by these companies on both a fleet-wide and a per tractor and trailer basis to determine what the correct portion amount of use tax would be. And a use tax that was framed in that manner, which we don't have here, but if it were framed in that manner, we couldn't possibly raise any issues under complete auto transit. It would be completely fairly apportioned, and we would have no challenge under discrimination or the fourth prong of complete auto.
All right, thank you.
Thank you, Your Honor.
Good morning.
Good morning,
So
Chief
what
Justice.
do we do with this regulation?
Mary Kay Toy, appearing for the Commissioner of Revenue, along with Joseph Tierney, may it please the court. What we should do with this regulation is we should take it in context, first of all. The regulation is found at 7G. The first subsection does reference a sale or use tax paid to a state in which the sale or transfer occurred. That's not a direct reading of the reg, but the language that's complained of is pulled from that subsection. We know that in practicality, when a sales or a use tax is paid to another jurisdiction, it is typically done where the sale either occurs or where the property is transferred and registered. So we think that that language would likely capture 95% of the cases where this would arise. But to pull that out of context and say that the commissioner would use that to somehow deny the broad statutory exemption is just not correct. We're not asking this court to strike down that regulation. We're not disavowing our regulation. We're asking that it be read in context. Subsection H, which is the subsection and the exemption that was discussed throughout the audit, there's reference throughout the record appendix of that exemption, the auditor discussing that exemption with this taxpayer, provides an exemption for any application of the use tax that would violate the complete auto test. Now,
So to the extent that the statute, which your brother basically says is to be read consistently with the regulation, you're disavowing that reading, and you're saying that, in fact, the Department of Revenue would recognize other credits, even if not as described in the regulation.
Yes, yes,
That's
Your
the commissioner's position.
Yes, Your
The
Honor.
statute means something that is broader. So in other words, it would be all sales and use taxes paid to other states would be available to be credited.
Yes, that is correct, and that's based on a plain reading of the statute.
That's
the
7C
language.
we're talking about, right?
This is at section C, and this is 7C of 64I, the use tax statute, where our credit provision is provided as an exemption from tax. So the exemption is provided for sales upon which the purchaser has paid a tax or made reimbursement, therefore, to a vendor or retailer.
But but isn't that part of the problem? I mean, let me ask for some tax advice. I'm a Massachusetts company. I have operations in New Jersey. I buy a truck in New Hampshire, and it then goes to New Jersey where, let's assume, there is a use tax of 3%.
Okay.
Where it is used exclusively, doesn't come to Massachusetts for any purpose whatsoever. Number one, is that taxable in Massachusetts?
No,
Okay, because it doesn't come here, right?
it doesn't come here.
So if it has zero contact with Massachusetts, there's no tax.
That's correct.
All right. But the tax I'm paying, let's assume that it actually does come to Massachusetts from time to time and therefore subject to the Massachusetts 5% use tax. Do they get a credit for the 3% tax in New Jersey, even though it wasn't paid to a vendor or retailer? It was paid to the state.
That is correct, yes, I'm sorry. It would be paid to a vendor or retailer under the laws of any state, and then it goes on to say,
That's how it gets paid to the state, isn't it?
I'm sorry, it's
But a
paid
use
to the
tax doesn't
state
get
through
paid to a vendor or a
Oh,
retailer.
so you're saying the problem if it was self-remitted, if it was self-reported and
Well,
remitted?
they're always self-remitted if it's a use tax because the sale hasn't occurred in that state. That's why there's a use tax.
Right, so,
So we're talking about sales upon which the purchaser has paid a tax to the vendor or retailer, which suggests this is really all about sales, not about use.
but this provision does exist in the use tax, statute, and this is not the first time this court has addressed this language. This
So you're
language-
saying regardless of what the language might mean, it absolutely clearly says that if you've paid a use tax in another state, not where you bought the truck, you get that credit against any use tax that Massachusetts might apply.
That is correct.
And that is clear.
And that's, not only is that, yes, that's clear in the commissioner's public written statements, that was clear in the record. This particular argument regarding the regulation was raised for the first time in the appeal, and I think it was probably in the direct appellate review application. But we do still have testimony at the appellate tax board by the commissioner's auditor, Mr. Hutchinson, that discussed going through these questions and asking if tax was paid. He didn't say, and it wasn't his testimony, that they asked whether a sales tax or use tax was paid in the state. He didn't parrot the language of 7G. What he did was he walked through 7H, which is the broad exemption for any tax paid to any state or political subdivision. It's the commissioner's position here today that if we were to deny this credit, then the tax we have to give the credit to render it internally consistent. This is what we've always done. This has been recognized going back to the 80s, the M&T Charters case. It's different because I guess it's not a tractor trailer, it's a boat, but it's a similar piece of property that's been moved, purchased out of state, brought into the Commonwealth, acquired a taxable use. That's important to note here that Regency doesn't argue that we haven't met the statutory requirements of this use tax assessment. They're arguing that the tax is unconstitutional. In M&T, they argued that there was no statutory use. They also argued that it was unconstitutional, and the SJC found that the broad credit of 7C rendered the tax constitutional because any credit would be given, and therefore meant credit would be given for a tax paid to another jurisdiction, and therefore multiple taxation wasn't threatened.
So I know this doesn't relate specifically to this. So I'm a New Jersey company. I buy my trucks in New Hampshire. They're stored, maintained in New Jersey, but occasionally they have to drive through Massachusetts. Use tax owed to Massachusetts?
It's a highly factual, it's a highly factual situation, and this goes to the arguments, I think, that underpin the amici in their brief. Remember, there's the thrust of this appeal is all about internal consistency when it boils down to it, but there are still 4 factors that need to be satisfied. Here, we have Nexus. We have a company that is headquartered here.
Nexus might not exist in the New Jersey example I just gave.
Exactly. And there's also the 4th prong, which here, whether the tax is fairly related to the services received from the state. If the classic example of a train passing through Massachusetts in the night on its way to some other place, whether or not passing through briefly through the Commonwealth would satisfy that prong is also a question. Luckily for us on these facts, we don't even have to get to a blurry line. Regency is headquartered here, 68% of its workforce is here, 4 warehouses, a storage depot. They're performing half of the maintenance that they do here. Half is in New Jersey, half is here, and then the balance is performed by third parties. But to suggest that somehow Massachusetts should only be able to reach mileage belies the fact that they're also doing maintenance here, they also have workforce here, they have presence here. So to suggest that the use tax, which is of course applied to the use and storage and maintenance of those trucks here, should somehow be limited to just the miles driven on the road, belies the fact that other stuff is going on here. And it's also important to note that despite all of the contact that Regency has with the Commonwealth, if they had in fact paid a tax to Pennsylvania, New Jersey, we would have received no use tax, assuming that that rate was applied at a similar rate. We would have lost out, and that's because the Massachusetts use tax is part of a national system that was discussed in Jefferson Lines. Jefferson Lines discussed the case in the New Jersey Tax Court, KSS Transportation, where it was noted that credit provisions create a national system under which the first state of purchase or use imposes the tax. Thereafter, no other
What?
state.
Excuse me, the first what?
I'm sorry, where the first state of purchase or use imposes the tax.
Okay, so if the truck passes through Massachusetts on its way to Pennsylvania, having been purchased in New Hampshire, but Regency's here,
Right.
since it passed through Massachusetts first, we get the tax?
If we get to them first, because of course the next sentence is that thereafter no other state taxes the transaction unless there has been no prior tax imposed. So in the event that the trucks are purchased in various states that don't impose a tax, here it was New Jersey, New Hampshire, and then used in New Jersey first, that may be where the first use occurs. However, New Jersey has an exemption that exempts these trucks. So the first taxable use, I suppose, happened in Massachusetts unless they drove it through another state. There may be another state that didn't tax them. Indeed, no tax was paid here. So there may be other states that had a claim, but Massachusetts was the first to impose that tax. So if we had imposed the tax like we did and we went to them and they said they paid a tax to other jurisdictions, they would have been credited. That much is clear. I just wanted to note that this is not a new position with respect to offering credit. This was discussed on the record. This isn't something that just came up on appeal. We discussed the possibility of credit even at the time of audit here, and the appellate tax board noted that.
So going back to my example again, so is there ever a time when you would say to a company, or the department would say to a company, well, yes, you did pay a tax in Pennsylvania, but a use tax there, but actually your trucks passed through Massachusetts first. You shouldn't have paid that. You should have paid it to us. Has that ever come up?
For a use tax?
Right.
No, it hasn't.
You said the first one to assess the tax wins. It's not the first state in which the vehicle is used then.
That is correct, because if the other state, if in that case, Massachusetts could not tax because the tax had already been imposed. And if we were to impose a tax without giving credit, the way it really works is that a taxable use has happened, but that the tax is exempted due to the credit provision. So the property would be taxable technically, but there would be no tax due because you'd receive a full credit for what was paid to the other state.
Could I turn to the external consistency, because you say this case really boils down to internal consistency, but if external, I think the point that Regency makes is, if external consistency looks at, is what you're being asked to pay sort of your fair share related to your operation.
Right.
So that gets Regency to the mileage. So so it isn't, that's not an internal consistency issue. So what do you say about that?
It's not, and this is a tough issue for when you're applying external consistency to a sales or use tax, because it's not a gross receipts tax. Central Greyhound looked at gross receipts tax. When you have a gross receipts tax or an income tax, you're going to be looking at the apportionment and how that tax is getting paid year in and year out, based on what your activity is within the state. Here, the external, it just doesn't line up well, unfortunately. When the appellate tax board was looking at this, you saw them keep coming back to the fact that a credit is offered, therefore we're not taxing more, the Commonwealth's not taxing more than their fair share.
What are the key cases on that There are cases specifically dealing with this, are there not?
Well, Jefferson Line certainly discussed external consistency. Central Greyhound did.
The context of a sales and use tax?
No, I can't find I could not find a case that failed based
Well,
on.
except, I mean, Boyd, right?
Well, of course, and Boyd is an interesting case. It's not binding on this court. It's a civil appeals of Alabama case. It's the only case that you could really find that Regency relied on even at the board. It actually failed on 3 different grounds also. It's important to note that the first thing the civil courts of Alabama found was that if that sale had occurred within Alabama, it wouldn't have been taxed, and that was also a major problem, was that Alabama was seeking to tax a sale that, a use of a tractor trailer that if purchased within Alabama would have been exempt. A second grounds for throwing out that assessment was also that the statutory use wasn't met. So there was also a question as to whether or not the statute and it was actually triggered. And then, yes, the third problem was this apportionment by mileage. But again, if we were to apportion the use tax, the use tax is a complement to the sales tax, and it is attaching here because the tractors and trailers are used and stored and maintained here. But if we were to only assess a tax based on 35% of the miles, that would ignore that maintenance is happening here, that presumably those trucks are being sent around by staff that work here. It wouldn't capture the full use here. That's why it's just impractical and to try to see which percentage is being used here. Say New Jersey said 10% of the miles are traveled here, so we'll take 10%. But perhaps Massachusetts would say, well, really 70% of your work with respect to these trailers is done here. So rather than apportion this up, what the states have done is adopted this national credit. The credit would have been offered here if they had paid tax elsewhere. It's unfortunate that this regulatory argument was not raised earlier. We could have done more with it. But I think the record is sufficient to show that we asked whether taxes were paid elsewhere. It was not limited, that 7H is broad enough to control, and that the broad statutory language found at 7C would provide for a broad credit.
So basically, unlike income or gross receipts or something like that, the way, in this context, you just say apportionment per se doesn't make sense. So in lieu of apportionment, you do this 100% credit, because obviously apportionment, you might be apportioning how much, how much of that use tax goes to New Jersey versus Massachusetts. But the system is first in line gets 100%.
Yes, and sometimes the Commonwealth wins and sometimes the Commonwealth loses. And in this case, no taxes paid elsewhere, so we would be entitled to the full amount of use tax.
All right, thank you.
Thank you.
Thank you.